Yes, so I think we're good to get started. Good morning, everyone. Today is Tuesday, March 18th, 2025. The time is 9:29 a.m. And this is a pre-hearing conference, in the matter of Robert Devine before the Massachusetts Peace Officer Standards and Training Commission. We are convening remotely over Zoom, and this pre-hearing conference is open to the public and is being recorded. The Honorable Kenneth J. Fishman will be the presiding officer over today's pre-hearing conference. My name is Lizzie Smith, and I'm the hearings administrator for the Post Commission, and this matter is now before Judge Fishman.
Good morning again, and if counsel would simply state their appearances.
Shaun Martinez for the Post Commission's Division of Standards.
Okay,
Robert Stowe on behalf of Robert Devine, who is present with us today.
all right. So we scheduled this with the hopes that having provided the parties with more time to examine additional discovery that was received, to look through that material, see whether it's provided a lot of new information or was essentially duplicative of what you've seen in the past. And also with the expectation that today we would be able to finally schedule an actual hearing in this matter and preliminary hearings if necessary for motions, etc. So, Mr. Stowe, why don't you tell us where you stand on the discovery issue?
Yes, I did receive the information. I did go through it. I have found nothing really that's different than what was already been produced. I think we're ready. I did talk to Attorney Martinez yesterday, and I think we're ready to get a couple of dates, final pretrial, a motion in camera date, and a hearing date.
Okay.
I think we're ready to go.
All right. And is it fair to say that you anticipate on behalf of the respondent refiling several motions, substantive motions?
I do. Some motions in limine. That's essentially it.
Okay.
And I would request those be heard in camera. And I also had a question about filing those motions because I will be referencing some of the information that is subject to the protective order. And I didn't know the best way to accomplish maintaining the privacy or the integrity of the order and also getting the information to Your Honor that I'm opposing or moving to limit.
You also, well, before I ask Mr. Martinez to comment on that, do you also anticipate a need to have any portion of the actual hearing in camera, if you will?
I think there's documents and evidence that should be held in camera and not disclosed. I think Attorney Martinez and I have discussed that. I don't want to speak out of turn, but I think there are portions of it that probably should be withheld without referencing what they are and not produced as in the general public. With that said, I defer to Attorney Martinez.
So, Mr. Martinez.
Yes, I think that that's accurate. I expect that, for example, cross-examining witnesses, I do expect there to be clear breaking points when we get into, the substance of the documents where we could close the hearing if needed. I do expect that any witnesses that testify would likely be confronted with exhibits and within the post regulations there seems to be a preference to keep written documents confidential, especially when they're exhibits to the hearing. And I think that it's realistic once we're cross-examining witnesses to sort of give a signal, this is the time when we're going to be getting into the substance of the documents, and those portions would likely be preferable for both sides to be closed.
It would be helpful to think as we're preparing for this that to the extent both sides can do that, that you alert us ahead of time as to what documents will fall into that category. So just in the heat of a hearing, sometimes it's better if we all know where the sensitivity is in those matters that may be subject to the protective order as well.
Yes.
We've actually discussed basically the 5 major issues of evidence that we think are relative to the hearing. Whether or not they're admissible is not agreed upon, but we've identified 5 major areas that we think that there might be some issues confidentiality that should be raised, so.
Right. Well, we'll, at least at the final pretrial, we ought to be able to identify those. And again, so we can be prepared for that when it comes up during the course of the hearing. So let's do this. Let's work backwards. Let's try to get a hearing date, and then we can fill in the other dates that we need in terms of a final pre-hearing conference and an motions hearing date. Lizzie and I were talking shortly before we went online with you folks about an appropriate time. Do you think that a May date is feasible for the parties?
I am not, I have a products liability trial / negligence case that's supposed to start in May, and it should go for about a week. It's starting on May 12th. I'm sorry, my final pretrial is May 12th. It's starting on the 18th. I'm on the 19th. I'd like to stay away from that date because it involves about 12 witnesses and experts and things along that line. So I'd like to stay away from kind of the middle of May. So if I could go into June.
Mr. Stowe and I yesterday when we spoke did actually sort of outline a potential schedule, and we're working out what the times that we thought we needed for each step in the process. What I came up with was either late May or that first or second week of June. I'm happy to walk through the sort of the proposed timelines that we discussed yesterday.
No, that'd be very helpful. Why don't you go ahead and do that?
So we had proposed finalizing, our initial witness and exhibit list as well as the form of the exhibits within 3 weeks. Having those to each other so that we can do the best motions in limine as possible without having to revisit any issues, which would take us to April 8th. The motions in limine 2 weeks after that. The oppositions to the motion in limine a week after that. And then potential arguments on the motions and a final conference 2 weeks after that. And then the hearing, picking a hearing date, or if we need to adjust the hearing date, that would take place at that final conference or motion arguments, which if we stuck to the timeline would be in the, sort of the middle of May.
Mm. Well, the middle of May is when Mr. Stowe has a problem, right?
Correct.
So I guess that could potentially be either the week following his trial or the week before. I imagine that trial prep may be an issue, but either the week following or the week before, and then I don't think we'd need very much time after that final conference to prepare for a hearing. I mean, we'd be preparing for the hearing over the following 2 months regardless.
This is a little unusual. I'm going to have you just stay put. There's one date I'm concerned about for my own schedule, but I need to check on that. So it's not that I'm leaving because I don't want to talk to you, but hang on 1 minute. All right. Thank you. So just as we're scheduling things, I know that I'm unavailable from, let's say, like June 8th to the 18th. So those days are out. And then or sometime in early July as well, I think sometime after July 4th, something like the 7th or something like that for a week. So other than that, I will make sure I make myself available. And then we'll also work around the scheduling as affects all the other stuff the commission has scheduled, but and Mr. Stowe's trial. So having said that, do you think we can accomplish all that needs to be done pre-hearing the earlier part of May to far enough away that we don't get right up against Mr. Stowe's trial?
I do.
Okay,
I think so.
all right. So when you did all these 3 weeks, 2 weeks, 1 week calculation, did you put dates on that?
I did this morning. We didn't yesterday, but I did this morning.
Yeah, I didn't see the dates, but if I have the dates, I can confirm them right now.
Yeah, why don't you do that, Mr. Martinez?
So the witness and exhibit list, along with proposed copies of the exhibits that would be admitted, would be April 8th.
Okay,
The motions in limine would be April 22nd. The oppositions or responses would be April 29th. And then I had written down potentially 2 weeks after that would be the arguments or final pre-hearing conference. But if we move that to the week forward, it would be May 6th. The week preceding that trial.
so May 6th for the final hearing, you're saying?
The final pre-conference,
The final.
Yeah, final pre-conference, and if there need to be oral arguments on the motions.
Okay. So as a practical matter, we'd bump up, well, as you said, but after that, there's no reason this hearing itself can't be scheduled shortly after, as long as I've had enough opportunity to review and decide those motions ahead of time.
Right.
I'm just trying to be sensitive to tell me the start date, Mr. Stowe, again, when you have your trial.
I'll go back to May. I think it's the 19th.
19th. Oh, okay.
Final pre-trial is the 12th. My trial starts on the 19th.
So what if we, well, what do you folks suggest for the actual hearing date then?
I suggest, I know you're away either the first week of June or when you come back, I guess it would be the week of the 22nd of June.
Yeah, I'd like to not do it quite that late. So where's your trial by? Is Superior Court?
Yeah, Norfolk Superior.
Okay.
It's going on, it's scheduled to go on at the same time as the Karen Reed case, which is the same courthouse. So I don't know what's going to happen if it gets continued or what, but I don't think it's going to get continued. It's been scheduled since last year.
I don't know, I sat as Raj in that courthouse for years, so that they can have two trials going on at the same time, even though the Reed case is pretty and involves a fair amount of interest. So what about that first week in June?
I believe that should work for me.
I have the 5th and the 6th of the first week work for me. The other days I have something scheduled.
Well, give me a look into your crystal ball and tell me how long you think this hearing will last.
So we had discussed yesterday, I would expect the only witnesses that may be up in the air right now would be mostly authentication witnesses to authenticate evidence. I anticipate that the division would be able to be a little creative, possibly getting written authentication. But if those witnesses were needed to testify, that's the only reason that I would think that could extend this hearing. But I do think at most the hearing would be a day to a day and a half. I know that Mr. Stowe had proposed a couple witnesses. We haven't talked about what the substance of those witnesses, what they would be offering. However, it sounds like at most there'd be 5 witnesses, not including the authentication witnesses. And I think realistically a day and a half is not unreasonable for that.
I mean, 5 witnesses between you.
Correct.
Okay. So what about using the 5th and 6th? Actually, I should be talking to Lizzie now. Are those dates, do they look available to us?
Yes, those are fine. And just to confirm, the hearing would be in person at the post commission office?
Right.
Okay. Yeah, that works.
Stowe, are you comfortable with that?
I am.
All right. So it's the June 5th.
And in terms of start date, or start time, sorry, Attorney Stowe, where are you coming from? Will
I'm
that
in
be-
Boston. I'm in West Roxbury. part of
Oh,
it.
okay. So does 10 o'clock AM work for everyone?
Yes.
Mr. Devine, does that work for you?
Yep, that's certainly good for me. And that's good. I like the fact we have a bit of a break between our final conference and potential hearing on motions in limine and the hearing itself in case there are issues that need some time to decide. So, Lizzie, did you get all those dates?
Yes, I did. Thank you.
Okay, just to review the finalizing the lists and copies of exhibits, April 8th, motions in limine, cert filed on April 22nd, oppositions filed a week later on April 29th, a final conference on May 6th, and the actual hearing itself on June 5th to June 6th.
Now, Your Honor, the May 6th date for the final pretrial conference, will that be in camera? Will that be, because I suspect we'll be discussing evidentiary issues that will be involved.
I'm sure we will. We may want to do this in person to the extent there are documents I need to see that rather than having them all where I'm speaking to you from right now. Why don't we do that in person on May 6th at the post-commission hearing room? All right.
Sure. What time, Judge Fishman?
10 is also good for me then. Does that work for both of you?
Yes.
Actually, sorry, on the 6th, we do have a pre-hearing conference in the morning. Would the afternoon be okay for the parties?
Afternoon would be better for me.
Yeah,
That's fine.
I just as long as we leave enough time for any hearing on the motions itself. If
Sure.
I think that'll be right. What time do you usually start up there for afternoon hearings?
So we don't have anything after like noon, so we could do any time after that. Would 1 PM be okay for the parties?
That
Counsel?
works for me.
Okay, 1 o'clock. Are there any now? Don't as you would. You two are very conscientious, and I appreciate that. But if there are issues that arise in the course of this preparation that need attention earlier on, don't hesitate to contact us for the purpose of scheduling something that isn't on our schedule right now. I don't have any. I'm not imagining any particular issue, but I don't want to hear about it at the final conference that jeopardizes the hearing date itself. Okay.
Okay.
As far as filing motions, Your Honor, what is the best way to file it to maintain the integrity of the protective order?
Well, let me put it this way. For any motion that you remotely think may be contain information subject to a protective order, you need to file those in the how are we receiving those, Lizzie, at this point?
We received them via email with a copy to the other party. So if you email the post review email, that's the one that I've been sending emails out. You can just file it that way, and I'll make sure it gets to Judge Fishman.
All right, but why don't you indicate specifically on there, identify it as attaching documents that are sensitive to the confidentiality requirements?
Okay.
All right. Any other matters you think we ought to be thinking about at this point?
The only other matter from the division's perspective is that I did relay to Mr. Stowe yesterday the sort of the route, the potential route that could resolve this case without a hearing. The only way that I saw it being resolved. The last date for that, because the agreements need to be approved by the commission. The commission's May meeting is May 15th, and materials are due a week before then. So the last opportunity to resolve this case without a hearing would be May 8th. And we need to have a agreement at that point.
This will be a hearing.
Okay. Well, that's fine. Certainly entitled, certainly entitled to a hearing. I don't have a problem with that. Sometimes circumstances change, so even if it's a date we have no need for, let's just attach a date to it so that if circumstances change. So literally you're saying, Mr. Martinez, in order to do this, you'd need to have an agreement in place by May 8th?
Yes, that's correct.
So let's put that as a date for the filing of any agreement concerning resolution of this matter in advance of the hearing, having in mind that it sounds extremely unlikely that that's going to happen. So, all right. Any other matters?
Judge Fishman,
No.
just before we conclude, the parties, when submitting any motions related to the protective order, please just indicate that, please indicate in the subject line of the email, just that the motion may have like protected information, so we can be clear.
Yeah, just that's true. Just alert, because you don't know how these things flow through the system occasionally. So we want to be right on top of that. That's a good idea.
Agreed.
Okay. Anything else?
No.
All right. Thank you, gentlemen. We'll, I guess we next see each other on May 6th.
Thank you.
May 6th in
Thank you.
person. Thank you.